As to the usage in Garse and Bainimarama, there was an act by the executive arm of state, and this was considered unconstitutional in the Court of Appeal. This recognizes the separation of power as fundamental foundation of our legal system. The arms of state are separated not only for the aim of independence and impartiality, they are separated for the very purpose of accountability. We need accountability through checks and balance. The judiciary, in the case of Garse and Bainimarama, found that certain acts by the executive overrode the Constitution. My lady, in this case at hand, government's decision to direct funds to infrastructure instead of social protection undermines women's rights. The appellants humbly do not seek an upset between the arms of state. Instead, the appellants seek state responsibility of social security for gender issues. My lady, the Court of Appeal in Garse and Bainimarama considered the core argument based on a national crisis. Similarly, in this case, counsel respectfully submits to the court that gender issues in Fiji. My lady, if the state still does not recognize the issues is a national crisis, then a recent survey by the Fiji Women's Crisis Center should be more than sufficient. 64% of women in Fiji still experience intimate partner violence. Let's go to the Pacific. 1 in 5 women experience sexual harassment in the workplace. 2 in 3 women are victims of violence by an intimate partner in the Pacific. The oldest rape victim in Fiji was an 83-year-old woman. It gets worse, my lady. The youngest was a mere toddler, a little girl of only 6 months old. This is a national crisis, my lady. Therefore, we submit to the court on the binding precedent from the Court of Appeal that presided on Garse and Bainimarama respectfully. My lady, on to 1.3. International law on justiciability of state responsibility for gender issues is relevant in the case at hand, considering that Fiji has already ratified of all forms of discrimination against women, also known as CEDAW, since 1995, and also the ratification of the Universal Declaration of Human Rights. My lady, counsel respectfully makes the following submission on the ground based on the following provisions from CEDAW. First of all, our parties condemn discrimination against women in all its form. They agree to pursue by all appropriate means and without delay a policy of eliminating discrimination against women, and to this end undertake A, to embody the principle of equality of men and women in their national constitution, legislative and other measures. C, to establish legal protection of the rights of women. D, to refrain from engaging in any act or practice of discrimination. Take all appropriate measures to eliminate discrimination against women by any person, organization, or enterprise. F, to take all appropriate measures, including legislation, to modify and abolish existing laws. G, to repeal all national penal provisions which constitute discrimination against women. My lady, on this Article 2, counsel humbly relies on Part C and Part F specifically. On Part C, to establish legal protection of rights of women. It can be said, my lady, that politicians are quite unfair to women at the moment. We need this 1.8% added to the national budget, so to eradicate violence against women and children. For F, to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices which constitute discrimination against women. My lady, customs and practices in Fiji, it is quite known that our customs and practices involve worrying about roads and bridges. When we are to be worried about human lives, when we need to be worried about our women, what is the use of these roads and bridges if our women never feel safe to walk on them alone? My lady has no question, counsel. Now I'd like to move on to 2.1.2. Thank you, my lady.
Proceed, counsel.
On 2.1.2, Article 3, state parties shall take in all fields, in particular in the political, social, economic, and cultural fields, all appropriate measures, including legislation to ensure the full development and advancement of women for the purpose of guaranteeing them the exercise and enjoyment of human rights and fundamental freedoms on a basis of equality with men. My lady, the appellants, of course, recognizes the local legislation in place by the government. We have the Domestic Violence Act, we have modified and amended our criminal act. But the truth of the matter is that legislation exists, but we want overview of all social, economic, and cultural fields so this population, women, could enjoy basic. Article 4, my lady, adoption by states parties of temporary special measures aimed at accelerating de facto equality shall not be considered discrimination as defined in the present convention. My lady, this offers the court a solution, a temporary solution. It is okay if the government does not want to give us its 1.8% now or in future, but what we need is a temporary special measures. What we need to do is to empower these women, and in order to empower these women, we need to first of all recognize and acknowledge the fact that women's rights are still very much undermined in our country. We can have